So we're on the record in docket 2201-865. That's Glacier Property Management versus Anthony Duncan and Alexis Duncan. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Good afternoon. Sam Dewar here on behalf of plaintiff.
And ma'am, you are Alexis Duncan?
Yes.
And you're joining us by Zoom today?
Yes, sir.
Is Anthony Duncan with you?
Yes, sir.
Yes.
All right. This is the time set for a formal hearing in the matter. Are you ready to go to formal hearing, Ms. Duncan?
Yes, sir.
I mean, usually we do formal hearing live, so I'm wondering if you're actually ready to go. You're not represented by counsel?
No, sir.
All right. Would you like the opportunity to speak with Mr. Dua today concerning some of these issues in the case? You're not here in person. You don't have legal counsel. So I'm wondering what options you might have in regards to actually having a hearing today.
Yes, sir. I would like to speak to Mr. Dewar.
All right. Mr. Dua, would you be amenable to speaking with Ms. Duncan in a breakout room?
Of course, Your Honor.
Now you can do the breakout room, please. All right. When you join in, we'll add you and he'll put you in a breakout room.
Okay, I'll just go into the one.
All right. Thanks. Just let me know when you're.
I will. Thank you.
And Mr. Brown, are you ready on H&N Holdings?
Yes, Your Honor.
All right. We might have to give, we're a little early, but is there a Salvador Rivera in the Zoom courtroom? I don't see one. How about in the physical courtroom? Any Salvador Rivera? Any Amy Rivera? All right, Mr. Brown, let's give them about 5 minutes and then we'll call the case. They seem to fail to appear at this point.
Thank you.
How about on Dame Darman LLC? Is there an Amy Rivera? Oh, same one. Okay. Is there a Shani Miralis Santiago? Shani Miralis Santiago?
Your Honor, that case is a dismissal. We sent one into the court.
All right.
They actually paid.
Perfect.
Thank you.
So I will indicate for the record, let's go ahead and call it and we'll say it for the record and then we'll let the dismissal is not caught up with the file yet, but on the record, docket 2202-164, that is Darman LLC versus Shani Miralis Santiago. Mr. Brown, your appearance for the record.
Yes, Attorney Chris Brown representing plaintiff requesting that the matter be dismissed.
Okay, plaintiff request matter will be dismissed as granted.
Thank you.
And we'll await the dismissal to catch up with the file.
Thank you, Your Honor.
That's the one I was talking to you about.
All right, let's go ahead on. That was Darman. And then Mr. Akanicki, are you here on East Side Community?
Yes, Your Honor.
All right. We'll call to the record. And is there an Arnold Winston?
Right.
And an Alicia Winston?
She don't stay with this boy. Yeah, she don't stay with him. It's just me and my son.
All right, Mr. Winston, I'll have you come up here. All right, we're on the record in docket 2202-614. That is East Side Community Action. Versus Arnold Winston and Alicia Winston. Will the parties please introduce themselves for the record?
Good afternoon, Your Honor. Robert Akanicki, attorney for Eastside Community Action Center.
And you are Arnold Winston,
Yes.
and you're indicating that Miss Alicia Winston is no longer in the residence.
No. Yeah. I
All right.
told him that when the last couple of times that we've been in court, I was also wanted to ask if I can get an attorney because
All right, hold on 1 second. And so Alicia Winston is not in possession, according to you, Mr. Winston.
no.
All right, this is the time set for a formal hearing today. Mr. Akanicki, I'm going to inquire into Mr. Winston. He seems to be without counsel today, and I'm going to ask him some questions, all right?
Okay.
All right. Mr. Winston, I have at a previous October 26th, you met with Legal Services of South Central Michigan, and then that was on October 26th, 2022. You are not with counsel today?
I am not with counsel.
Okay, when you met with them, who did you meet with?
I don't remember. I don't remember. It was,
But I can look back at the videotape and tell you who you met with.
Okay, if you can do that, then I
And then what?
the person basically told me that that I don't qualify, and I asked her why did I not qualify because I'm on Social Security and I'm on
It generally takes at least 15 to 20 minutes to take an application through the process. And then they usually tell you within the next 24 hours.
They didn't give me a reason why. You can go back and look at the tape
And
if you would like.
so to date, on December 28th is the first time you've come to court
Yes.
without a lawyer?
Without a lawyer.
And you found out on October 26th that you didn't have a lawyer?
I found out that I didn't qualify for it.
So that was 2 months ago.
I mean, I don't have any funds to go and get my own attorney.
But did you follow up and ask them how come that they didn't sign a lawyer to you?
I didn't ask them any questions because they told me that I don't qualify for an attorney. So that's the reason why I didn't.
It just doesn't add up because I work with them every day, and they seem to take anybody who doesn't have finances.
Yeah, you can ask them yourself. I'm not gonna lie to you. I'm telling you. What they
So
told me.
are you prepared to go to hearing today?
No.
Mr. Akanicki, any comment on this?
Your Honor, this is a really straightforward case. I mean, a hearing would take about 5 minutes. There's a 30-day notice that was sent a very long time ago. Now, Mr. Winston does not have a lease that's current. He's a holdover tenant. I'm very willing to discuss with him and work out an actual move out date. But otherwise, I don't know. I'm not really amenable to too many other adjournments on this. I mean, he's kind of just
Correct.
at this point.
I would agree with that. Mr. Winston, your options are limited at this point. We can have a hearing today, or you can meet with Mr. Akanicki and somehow get a move out date so that you have an understanding of the date of move out. Or we have a hearing today and Mr. Akanicki puts on his proofs, which at this time you're a holdover tenant. So there doesn't seem to be a lot of proofs to be had.
What does a holdover tenant mean?
It means there's no lease associated with you.
Well, I had a lease when I originally came.
Well, that's what the proofs are for, Mr. Hawk. That's what the proofs are for, Mr. Winston. So would you like to meet with Mr. Akanicki to discuss some of these matters and see if there's an appropriate date that
And I mean that wasn't the only thing. Like I asked to see I got from through my DHS worker. I asked her, saying to see about paying.
Well, on October 26th, did you see a video concerning all your resources available 2 months ago?
I seen the videos that said
Okay,
everything that I can.
and did you talk to DHSS about rental assistance?
Yes, I did.
And what did they say?
She told me to go to the Action Community Center. He told me to go to the Action Community Center and actually get how much I owe. So
I
then
think
that
you
way
should
he
talk to
can pay.
Mr. Akanicki about your options here, okay, sir?
So then that way I can pay it. Okay.
All right, so we're gonna set up Mr. Winston on an iPad and we'll put you in a breakout room with Mr. Akanicki, all right?
Okay.
you might want to, Mr. Rosa, would you be available to see Mr. Winston concerning any matters that he may have sometime in the near future? I can give him your card.
Absolutely, Your Honor.
All right. All right. I'm gonna have Mr. Akanicki and Mr. Winston placed in a breakout room, and then we'll go from there. All right, Mr. Brown, I think we have another case. It's the Frankels, Michigan versus Adanya Goodall and Clevin Laster. Is that your case today, sir?
Yes, Your Honor.
All right. Come on up here, Mr. Laster. All right. So we're on the record in docket 2202-620. That is the Frankels, Michigan LLC versus Adanya Goodall and Clevin Laster. Will the parties please introduce themselves for the record?
Yes, Attorney Chris Brown representing plaintiff.
And so you are Clevin Laster?
Yes.
And you're indicating Adanya Goodall is not here.
No, she don't live as a dwelling anymore.
Okay, and it's your indication on the record from Tenant Laster that Miss Goodall no longer lives at the property. Is that correct, sir?
Oh, yes, over 3 years.
All right, this is the time set for a hearing in the matter. I have an indication that the parties met on October 26, 2022, that Mr. Laster was working on rental assistance on that day, and it was moved, the formal hearing was set for today at 1:30. Mr. Brown, have you had the opportunity to speak with Mr. Laster on this?
I have not. However, I have had an opportunity to speak with my client. It looks like he is approved for 3 months rent. And I believe an email was sent to him from my client directly to him today at 10:45 a.m. asking him how he was going to pay the balance that was due after we received those 3 months of rental assistance. It looks like the balance that's left over is $2,337.60 after, with the understanding that we will be receiving assistance. But that's after, and even only if we receive that assistance for 3 months,
Right.
which I
Mr.
believe has been
Laster,
approved.
have you been able to check your emails for that? Do you have that on your device, the ability to check your emails?
Yeah, I had emailed them early this morning,
Okay.
but it was Garno Properties, and I never heard of Franklin.
Okay, so I think that's the Frankels is for our docket. That's Garno Properties, Mr. Brown.
That is correct, Your Honor.
All right. What I'm going to do here is, since we have the iPad being used up right now, I'm going to have Mr. Laster take a step into back into the seats, I should say, I guess, for lack of a better term. And Mr. Brown, would you be amenable to meeting with Mr. Laster to kind of work out some of the details of this?
Yes, Your Honor.
All right. So Mr. Laster, take a seat in back. Once the iPad is done, we'll put you on the iPad,
Okay.
and you can talk to Mr. Brown about this. All right.
Thank you, Your Honor.
All right. Thank you. Mr. Dua, are you set on your case?
Yes, Your Honor.
All right. And that was Mr. Duncan,
Mr. and Mrs. Yes.
Mr. and Mrs. Duncan. And are they out of the breakout room?
I don't want that. I won't leave.
They won't. All right. All right, we've got Miss Duncan back. Miss Duncan, I'll have you unmute.
Hello.
Thank you. So we're back on the record in docket 2201-865. Mr. Dua, have you had the opportunity to speak with the Duncans in a breakout room?
I did, Your Honor, and I am pleased to say that we've come to terms on a proposed conditional dismissal for your review.
All right, so conditional dismissal. Did you want to put the terms on the record?
I would be happy to, Your
Okay.
Honor. Your Honor, the conditional dismissal would state that the right to retain possession amount is $2,275.
All right.
There are $191.38 in costs in this matter, totaling $2,466.38. This amount needs to be paid on or before January 16th, 2023 to prevent plaintiffs from attempting to reopen the case and doing the default along with the order of eviction.
So if the conditions for the dismissal are not met, there'll be the conditional dismissal will be enforced.
Correct.
And do they have your permission to sign any document that you would provide to the court?
I did discuss that with them, and yes, they did give me permission to sign the conditional dismissal, and I have one of the defendant's email address to email a copy of it to
All right.
when I email it to Your Honor.
All right. So, Ms. Duncan, is that your understanding? Was there anything that was said on the record that you disagree with?
No, sir. Everything is
All
correct.
right. All right. So we have that January 16th date would be paid the $2,466.38 will be paid by January 16th. If not, the conditional dismissal will be enforced. And you've given Mr. Dua permission to sign the document and to send it to me on your behalf. Is that correct?
Yes, sir.
All right. Is there anything else for the record, Mr. Dua?
Nothing further from plaintiff, Your Honor.
Anything, Ms. Duncan?
No, sir.
All right. So the court will await the order to the dismissal to get the conditional dismissal to catch up with the file. And then I will sign it. Don't forget about that January 16th date. Okay, ma'am?
Yes, sir.
All right. We're all set. Anything else, Ms. Duncan, on 2201-865?
No, sir.
All right. You're free to leave the Zoom courtroom. Thank you. Thank you for your appearance, Mr. Dua.
Thank you, Your Honor. Have a good afternoon.
You too. And then let's go with Mr. Akanicki's case. And if you can put Mr. Laster, he will be talking to Mr. Brown. Back on the record in docket. Let me find the right. Let me make sure I have the right case. Let's do the one I just gave you to make sure I haven't messed everything up. That's 1865. Okay. And this is 2614. 2614. Here we go. All right. So we're back on the record 2202-614. That's Eastside Community Action versus Arnold Winston. Mr. Akanicki, did you have a chance to talk to Mr. Winston in a breakout room?
I did, Your Honor, and I think at this point, what we'd like to do is have the court a conditional dismissal that I'll submit later today that indicates that Mr. Winston will be out of the premises by January, by the end of January. So we have, so by January 31st. And if he is, the case is dismissed. Otherwise, if not, I could reinitiate this case and get a writ without notice.
All right. So possession to be turned over by the tenant And you said January 31st?
Correct, Your Honor, January 31st.
All right. January 31st, 2023. If those conditions aren't met, the conditional dismissal is enforced. And is there anything, Mr. Winston, that Mr. Akanicki just said that doesn't comport with what you talked about?
No, but I'd like to personally thank him. Thank you.
All right.
Thank you.
And Mr. Akanicki, it'll be, and does Mr. Akanicki have your permission to sign any conditional dismissal that we just talked about on the record?
Yeah, absolutely.
All right. So if you submit that to the court, I'll sign that.
Thank you, Your Honor.
That's a good deal, right?
All right, with that understanding, the court will wait for the conditional dismissal to be entered. Anything else for the record, Mr. Akanicki, on docket 22-02614?
No, Your Honor, thank you.
All right, Mr. Winston, good luck to you. You're all set. All right, you too.
Come on, sir. What's up?
Mr. Akanicki, did you want to put Mr. Porter on the record?
I assume he's not there or on Zoom, Your Honor. Is that correct?
Right. That's so. Is there a Marcus Porter in the Zoom courtroom? And I don't think there's one in the physical courtroom. I have somebody waiting in the Zoom waiting room, but that's not Marcus Porter. So let's call to the record docket 22-02615. That is Triple Diamond LLC versus Marcus Porter. Will the parties please introduce themselves for the record?
Good afternoon, Your Honor. Robert Akanicki, attorney for the plaintiff.
All right, this is the time set for a formal hearing in the matter, and it was scheduled for 1:30. It is now 2 o'clock. It appears that the defendant has failed to appear. I would indicate for the record that there was a fail to appear on October 26th, and there was service by attachment. Mr. Akanicki, how would you like to proceed?
At this point, Your Honor, we'd be requesting a default judgment. It's possession only. And the date for the writ would be January 9th, 2023.
All right, so default judgment is granted for fail to appear a second time. And the writ is will be set for January 9th, 2023, and you'll follow that up with the paperwork, Mr. Akanicki?
I will, Your Honor. Thank you.
All right. Anything else for the record in docket 22-02615, Mr. Akanicki?
No, Your Honor. Thank you.
Thank you. All right. So that's all for the record in that file. Can't read my writing. Mr. Brown is in a breakout room, correct?
I believe that's where we put them last.
Yeah, with the two. Then we have,
They showed up for the last one.
nobody showed up for the last one, did they? That's Wasbury?
Yeah.
22-287.
Your Honor, did you call the case that Mark Wasbury is the attorney of record for?
I have not yet. I'm just looking at it now. It is 22-02870.
Yes.
That's Cedar Place versus Ruth Koppler.
Good afternoon, Your Honor. Christopher Asphalt, 53129. My company has been substituted in for the attorney of record, Mark Wasbury.
All right. So that's your case, Mr. Asphalt?
Yes, Judge.
All right. This is the time set for a second pretrial in the matter or a formal hearing. It was the first pretrial. The defendant failed to appear on November 2nd, 2022. It appears the parties met in a breakout room, and this was set after a November 30th, 2022 pretrial for December 28th. I don't see Miss Koppler in the Zoom courtroom. Is there a Ruth Koppler in the physical courtroom? Mr. Asbach, this was set for 1:30. It is now 2:04. It appears the defendants failed to appear for the formal hearing. How would you like to proceed?
Your Honor, I would request entry of a default judgment.
Okay, entry of default judgment is granted. Did you want any numbers? Did you want to place on the record?
I'll just submit the judgment shortly.
All right. So the judgment is to catch up with the file. To be submitted by plaintiff. Anything else on the file 2202870, Mr. Asbach?
No,
All right. That's all for the record in this file. Thank you for your appearance today.
thank you.
And then Mr. Brown, are you ready on 222620? That is with Mr. Laster.
Yes, Your Honor.
All right, Mr. Laster, you can come up here and have a seat. We're back on the record in docket 22022620. And Mr. Brown, did you have the opportunity to speak with Mr. Laster in a breakout room?
Yes, Your Honor, I did. And we have a proposed consent conditional dismissal to put on the record.
All right, perfect. All right, you may proceed, Mr. Brown.
Thank you, Your Honor. Your Honor, the proposed conditional dismissal, the rent that's now due and owing through the end of the month of December is $4,768.41, together with court costs of $269.19, conditional dismissal amount of $5,037.60, and that would need to be paid on or before January the 16th by any sources available, agencies, any. Thank you. That's it.
So is that your understanding, Mr. Laster?
Yes.
That the $5,037.60 to be paid by January 16th? If a failure to make that payment would be the enforcement of the conditional dismissal. Is that correct, sir?
Yes.
Mr. Brown, did you need permission for Mr. Laster to sign his name to any document that you forward to the court?
Yes, please.
Mr. Laster, do you give Mr. Brown permission to what we just talked about as being part of the conditional dismissal to being forwarded to the court with the understanding that Mr. Brown would sign it with your permission?
Yes.
Okay.
Thank you, Your Honor.
All right. Thank you. You can go ahead and give Mr. Laster Mr. Rosa's card. And that might give you some place to start if you have any questions about rental assistance, okay?
All right.
All right. Anything else for the record, docket 2202620, Mr. Brown?
Nothing at all. Thank you.
Thank you. Mr. Laster, you all set?
Yes.
All right. Don't forget about that January 16th date.
Okay.
And Mr. Rosa will be expecting a call from you, okay?
All right.
All right, thank you. And then I think we can go ahead and put your other case on the record, Mr. Brown. I think we're well past the 1:45 time. So in regards to docket 2202-163, that is H&N Holdings LLC versus Salvador Rivera and Amy Rivera. Will the parties please introduce themselves for the record?
Yes, Attorney Chris Brown representing plaintiff.
And this was set for 1:30 today. It is now 2:08. This was set for formal hearing on October 5th. They're here. Mr. Rivera, oh, I see him. Okay. Mr. Rivera, are you here on your file today?
Yes.
All right. This is the time set for a formal hearing today. Are you represented by counsel?
No.
All right. Was it your intent to go to formal hearing today?
No, I talked to Brown already.
All right, Mr. Brown, do you have any update concerning this case?
I do, Your Honor. I have been texting back and forth with Mr. Rivera. He made a large payment yesterday. I sent him what his balance was currently, and I believe he said he can get that paid within 2 weeks. I would just need to know what he was thinking on exact date, and we can possibly do a conditional dismissal with whatever date that he lets the court know. Thank you.
All right, Mr. Rivera, do you have a date specific that you'll be able to meet your rental obligations?
Yes, the 10th.
So January 10th?
Yes.
So Mr. Brown, did you want to make that a part of the conditional dismissal, that the remainder payment to be made by January 10th?
Yes, and I'd like to go ahead and extend it to the 13th, just to make sure
All right.
that we're
Perfect.
all good to go. And may I put the terms on the record?
You may.
Thank you. The rent that's due and owing right now is $1,264.02. Court costs are $244.50. Total amount to be paid by that January the 13th is $1,508.52.
Right. Did you hear anything, Mr. Rivera, that doesn't meet with your approval concerning those numbers?
Yes.
All right. So you agree that will be paid by January 13th in order to enforce a conditional dismissal?
Yes, Your Honor.
Okay. So we'll set that for January 13th. Does Mr. Brown have your authority to place your signature on anything he forwards to the court concerning the conditional dismissal?
Yes.
All right. With that understanding, the court will await the conditional dismissal from plaintiff's attorney. And anything else for the record, Mr. Brown?
Just that we have another defendant, Amy Rivera, and I believe she's probably at work, I'm assuming.
Yeah. She's at work.
Say that again, Mr. Brown. I didn't hear that.
I'm assuming she's at work, and I believe Mr. Rivera just confirmed she is at work.
All right. All right. So you're here on behalf of both of you?
Yes. My wife. Yes.
All right. Anything else, Mr. Brown?
Nothing at all. Thank you.
Do you have any questions of me, Mr. Rivera?
Nope. That's it. Thank you so much.
All right. So
Happy
don't
New
forget
Year.
that January 13th date, and then I'll wait any conditional dismissal from the plaintiff's lawyer. Thank you for your appearance and have a nice day today.
You too.
Thank
All
you, Your Honor. Your Honor, just for the court's information, we also sent in another dismissal for a 245 case,
Okay.
Camelot Apartments versus Celestine, case number 2435.
All right. So I'll go ahead and call that right now. We can put that on the record.
Thank you.
So we're on the record in docket 2202-435. That is Camelot Apartments versus Enoch Celestin. It's my understanding, and Mr. Brown, your appearance for the record, and then you can make a record on the dismissal.
Thank you, Your Honor. Attorney Chris Brown representing plaintiff requesting a dismissal be entered.
All right.
Thank you, Your Honor.
So Camelot requested a dismissal and the court will await, and I think we already have that dismissal.
Thank you.
So that understanding, that's all for the record, docket 22-02435. Thank you, Mr. Brown.
Thank you, Your Honor.
All right. We're almost on time. I don't know what to do. I don't have that power. Let's see. Brooke, Frank, you're here.
Yes.
Mr. Brown, that's your case?
It is, Your Honor. I'd love to speak to Miss Frank in a breakout room if possible.
All right, Miss Frank, I'm gonna have yourself and Mr. Brown placed in a breakout room so you can talk about some of the legal issues before we have the formal hearing today. Okay, ma'am?
Okay. Do I
All
just
right.
click on something or?
You should get a prompt or it'll just move you right there.
Okay, thank you.
You're welcome. And Mr. Whitty, you're here on the Jeffries file?
Correct.
And is Angelina Reed here?
Check for her and not seen
What's that?
her. We've checked for her and not seen her.
All right. So, yeah. All right, so we're on the record in docket 22-02622. That is David Jeffries and Pamela Jeffries versus Angelina Reed. Will the parties please identify themselves for the record?
Good afternoon, Your Honor. Norman Whitty appearing on behalf of the plaintiffs.
All right, this was the time set for a formal hearing today, and it was set for 2 o'clock. It is now 2:16. I do not see Miss Reed in the Zoom courtroom. Is there Angelina Reed in the physical courtroom? It appears that the defendant has failed to appear today. I will indicate for the record that on October 26th, the parties were able to meet in a breakout room. It was set for formal hearing, a live formal hearing on that date. Mr. Whitty, how would you like to proceed?
Your Honor, this time I'd like to request entry of a default judgment in this matter. If I may approach, I have a default affidavit of judgment.
Yes, please. All right, so I've signed the default judgment for the defendants failed to appear. Both the judgment, landlord, tenant, and the default judgment. Anything else for the record, Mr. Whitty? I'll provide it to my court officer, and then he'll provide you with copies.
Awesome. Thank you, Your Honor.
All right, thank you.
Have a great day.
You too. Legal services, you're here for your 2:15? Okay.
Yes.
And was Ms. Keys gonna be here?
Yeah.
Okay. How about Mr. Wobu? You have not seen him? Okay. And Ms. Hart, you're here for the Levine?
Yes, Your Honor, it's a dismissal.
All right. We're on the record in docket 22-02735. That is Anmark Rivershell APA versus Travis Panera. Will the parties please introduce themselves for the record?
Good afternoon, Your Honor. Sumchit Hart, P69542 on behalf of Anmark Rivershell.
All right, and Mr. Panera is not here. However, Ms. Hart, you've indicated that you want to make a record in this case.
That's correct, Your Honor. We're moving to dismiss Mr. Panera's case.
And you'll follow that up with any paperwork?
Yes, Your Honor. I will get the paperwork to you this afternoon.
All right, perfect. Anything else for the record? Docket 22-02735, Ms. Hart?
No, that's it, Your Honor. Thank you. Happy New Year.
All right. Thank you. All right. Have a nice day. Have a happy new year if I don't see you.
Thank you. You too. Bye.
Mr. Brown's in the breakout room still, right?
Yeah, we're ready to go with the 215 case stuff.
Is that Mr. Wobu?
Yes.
All right. Let me make sure I've got my, these are brown. All right, so the parties can come up. We'll have legal services on the right. Ms. Robu, you can be on the left. Or whatever's easiest. Ms. Robu, you can go all the way over to the right. That'll probably be easiest, so you're not climbing over anybody. All right, Ms. Robu, you can be right here. So I have on the record 22-01985. That's Christian Wobu versus Kayla Keys. Will the parties please introduce themselves for the record?
My name is Christian Wobu.
Okay, Christian Wobu. And on behalf of Legal Services of South Central Michigan.
Aaron Strum appearing on behalf of defendant.
Okay, and defendant, and you are Kayla Keys, correct, ma'am? All right. I have twofold. I have a hearing for non-payment and then a motion today. So we'll take the motion first. Whose motion is it today? Is it legal services?
That's right, Your
Okay,
Honor.
you may proceed.
Thank you, Your Honor. Defendant is asking this court to dismiss plaintiff's complaint because this court lacks subject matter jurisdiction. Plaintiff improperly filed the complaint. Under the Michigan Summary Proceedings Act, a landlord seeking to recover possession of a property must first issue a demand for possession. And then if the defendant does not move out of the unit, then the landlord may file a complaint in district court. In this case, plaintiff issued defendant a demand for possession on April 8th, requesting that defendant vacate by May 9th. And defendant vacated and notified plaintiff of her vacancy over text message on May 18th. And then on July 6th, almost 2 months after defendant notified plaintiff that she had vacated, plaintiff then filed a complaint seeking to recover possession and $4,250 in money damages. By the time plaintiff filed his complaint, plaintiff had already recovered possession of the property and was notified of defendant's vacancy. And no claim as to possession existed when he filed the complaint. And therefore, it's not proper for plaintiff to use summary proceedings to seek money damages without there being a property at issue. So therefore, because plaintiff cannot seek possession of a property he is already in possession of, defendant asks this court to dismiss for lack of subject matter jurisdiction.
All right, response to the motion, Mr. Wobu.
Yeah, Your Honor, I'm a bit confused in the area they mentioned that I'm in possession of the property. I don't have any possession of the property. The text message, which is also.
Well, who has possession of the property?
So when I requested for the possession.
No, who has possession of the property now?
I don't know the person. It's the people they moved into the place.
But you rented to them, didn't you?
I didn't rent it to them. No, not at all. She's the one, she tested me, the information she told me to go and sign lease. You can see it in the case she sent to me. It's in the text. She said that I should go and sign lease with so and so person. That she's the one that it is in here. That is the one that should be. Hey, wanted to let you know. I moved out. His sister and the brother-in-law are staying there. They need a lease. They are going to be staying there now. They will have money for you soon.
So do you have a lease with the new people?
I don't have lease. Why should I be having lease? I don't know.
Because you're renting your property to somebody different.
I never rented. The only person I rented was car. I didn't rent it.
What? So do you have a copy of the lease that you've rented for the new people?
I didn't rent this. The only thing that I did was when she mentioned that I waited for them if they want to be rented house, they have to make payment, they have to sign lease, and they have to also sign agreement that they are going to take care of the back rent of Kala. So they kept on promising. They never done anything, and I've never taken any other step. I didn't receive a cent.
I'm a little bit at a loss that you didn't file against the people who are currently living there.
I didn't. I filed for the person that I have lease with.
But she doesn't live there anymore.
But when you mentioned that I still see her there, I didn't have a complete the idea or a conviction that she has moved out, because the people have been seeing the people there with her.
I have you filed a summons and complaint in this matter on July 6th.
On July 6th, yes.
Yeah.
But when she
the allegation is that she moved out way before then.
She has not moved out. She mentioned that
Miss Keys she still lives there?
I don't know, because I still see her over there around the area during that time she mentioned. And I don't know the people that they moved into the place. I don't know who those people are.
Well, it sounds like you should develop a lease with those people.
Listen, no, I didn't develop a lease.
But you should. I know that you should develop a lease with those people.
But I don't know who they are.
Well, let's find out for the record who they are now. Okay. So do you have the members? Do you have the people who live in the establishment right now?
Do I have them?
The names.
Yes, I have the names, but they're not living there.
So there's nobody living there.
Nobody there. And I was moved out before he even sent out.
So Mr. Wobu, right now there's nobody living there.
If nobody is living there, I can go and possess the property.
Correct.
Yeah.
But yeah.
But if I can have the motion that I can just go and possess the property.
I think you can. I don't think anybody lives there right now.
But the other time when there was a time
when was the last time you were at the property?
What, please?
When was the last time you were at the property?
The last time was 2020 with Kyla.
That was the last time you were at the actual property?
The actual property was with her.
All right. You haven't been to the property since that time?
Okay, no, I've gone to the place.
When was the last time you went there?
The last time was it was my wife that went in.
No, when was the last time you were there?
Okay, personally, the last time was that was we were removing trashes around the place. That was I can't remember, maybe either October or this. There was trashes they left around.
So well after July.
Yeah, after July, yes.
All right. And was anybody living there?
There were people that I saw there.
Did you talk to them?
I talked to them, yes.
Were they living there?
They're staying there. They said that I'm in contact with her.
Okay, but were those people living there? She doesn't live there anymore.
Yeah, but she's the one that I was of my.
She's the one that you filed for possession against.
Yeah, and
but she doesn't live in the property anymore.
Okay, but for that one, why I filed that one was I used to see the people with her over there, and when she tested me, I didn't. People were inside the house, and I cannot take possession.
Response? Any response from legal services? I'm a little confused by this because I don't know if you know who actually lives in the property now.
If she's not living, but if I have something to make it, because the last time we wanted to have a rental inspection, my wife, when they said that the dog were back.
Well, Mr. Wilbur, you've got to follow some rules here concerning landlord-tenant law. You know, you can't file possession for somebody who's not in possession of the property.
Yeah, but the honor, why I did for that one was still when she tested me, she moved in the people in, and I cannot have access to the place.
So you did not have access to the place in July?
Yeah, I'm not having access to the place.
When was the last time you were at the place?
The last time I
It was October.
around October. Why I went there was there was
Before July, did you go to the place to see who was living there?
Before July.
Yeah, when you filed possession in July. Before, did you go there to see who was living there?
No, I didn't. I can't.
You probably should. Response, ma'am?
Yes, Your Honor. If Mr. Nobu is discussing that he communicated with the tenants to pay Ms. Key's back rent, that would establish that he has a tenancy with them if he's requesting money from them, regardless of who they are. So for those reasons, we say that Ms. Keys has moved out of the property and no longer has possession of the property.
Well, I think the motion's pretty apparent that you have filed an eviction for possession against somebody who had already left the property. And therefore, this court doesn't have jurisdiction over that, okay? I wouldn't have jurisdiction over that in regard to possession of the property. If you want to sue her for money damages concerning some collections issue, that's a civil matter, but this is a landlord-tenant matter, and you've indicated that you want possession of the property, and she doesn't live at the property anymore. Who's got keys to the property?
I never had keys, Your Honor.
Your Honor, she has the key, and she had never given me key. This is what she mentioned. This is what.
Have you gone and talked to the people who live there?
Yes, I've gone.
Have they turned over a key to you?
No, they never done anything.
Have you talked to them about signing a lease or?
Yes, I asked them for signing the lease.
And they said no?
They said they don't have the money.
So they're trespassers. Or you're in a month-to-month tenancy with them by this point. If you've just allowed them to stay there, they're living month-to-month. Have you talked to a lawyer about this, sir?
No, I didn't.
You probably should talk to a lawyer about this. You probably should talk to a lawyer about representing your rights as a landlord in this matter.
Your Honor, how could I handle such a situation if somebody gives?
I'm not a landlord, so I don't know. It's not my responsibility. Your responsibility is to follow the rules as a landlord, follow the law, and to do things legally. I don't have jurisdiction. The way I see this, this isn't a complicated issue. I don't have jurisdiction because you filed against somebody who doesn't live there anymore. So maybe you should file against the people who haven't paid rent and who live there now.
Yeah, but the Honor, that's what confuses me is the way that I understand that if I sign agreement with her, at least I should have the house empty.
You should have the house empty. According to this person, they haven't lived in the house.
But they were in there. The people were in there. She's the one that moved them, and that's what she wrote to me.
I mean, anybody who's responsible for moving into the house after somebody leaves, you should be in some type of landlord-tenant relationship with. You're on a month-to-month with them, okay? So they should be paying you rent, not the person who's left the establishment. They don't have possession of it anymore, and you can't wait 2 months and file a possession against the person who doesn't live there anymore. Does that make sense to you? Why would you file against somebody who doesn't live there anymore?
Yeah, because Your Honor, because on 2 occasions that I passed by there, so I don't have the total conviction that she has moved. That is just a verbal. It's a verbal and written that she has moved out.
All right. Do you have any proof today that she's not moved out? I mean, this is set for formal hearing. Do you have any proof today that she's not moved out?
I don't have any proof on that one.
Okay. And it's my understanding that it is the representations of legal services of Central Michigan through this motion that she hasn't lived there since what, May?
That's correct, Your Honor.
And you're at a new address now?
Correct.
Mr. Robo, I don't have jurisdiction over this case. And I don't have jurisdiction. You probably need to find out who's living there now and to develop some type of lease arrangement or something, payment arrangement, in order to see who's living there now. If you have a case in which a civil case that you're claiming that Ms. Keys owes you money, you should file that civil suit. But we don't have a landlord-tenant matter anymore because she's not a tenant anymore. Does that make sense? All right. Anything else from legal services?
No, Your Honor.
All right, I'm going to grant the motion. At this point in time, I believe the motion is correct. This court does not have jurisdiction in this matter. I want to go to the request for relief. So I will grant. There's a baby in the room back there, and it's kind of funny. Grant the motion to dismiss. Grant to dismiss in that the court does not have jurisdiction. Jurisdiction, and I'll grant the motion for summary disposition. Ma'am, if you do know who's living in there now, I hope you provide those names.
Oh, he already knows. them.
Okay, if you,
Yeah,
because
contact
those are the people who should be on a new lease who are
He also has their
responsible.
numbers.
But my understanding is nobody lives there right now. There's nobody's in possession of it. So maybe you go in and have the locks changed, and that takes care of your purposes to make sure it's habitable so you can rent it out. Okay. Anything else for the record in docket 2201-985 from Legal Services of South Central Michigan? I want to make sure this is signed by Miss Pereira, but it's Miss Schrumpf. Okay, Schrumpf. Is there anything else? And you'll follow it up with an order?
I have a drafted order.
Okay,
Your Honor.
let me, sir, have you got an opportunity to see the order?
Your Honor, I have a question.
Okay.
My question, is it not possible also if I can have maybe a written thing for possession? The house have been sitting for almost 10 years.
I don't think anybody's in possession of it.
Okay.
So if there's nobody in possession of the grounds of the establishment, I'd go in there and change the locks and make sure nobody can get in there. Okay. But I don't want you to file on a property that's not in possession by someone. If somebody's in there, you may have to go through an eviction process, all right, of the new tenants who are in there, but not on the person who's out of possession, which is why I don't have jurisdiction. All right. Yeah, Nathaniel will make a copy for you. All right. All right, and this, of course, this motion for summary disposition takes care of the formal hearing, obviously. So anything else for the record in 2201-985, Ms. Schrumpf?
No, Your Honor.
All right, Mr. Wobu, if you have any questions about this, talk to the civil department that handle landlord tenant. But at this point in time, you might have a holdover tenant, which means that you have a new eviction process, or you might just have a full possession. You're in possession of it now. Which would answer any questions you have, okay? All right, that's all for the record in that file. Thank you.
Thank you, Your Honor. Thank you.
Mr. Brown back. That's good. So, Mr. Brown, are you back with us on Brooke Frank?
Yes, sir.
All right.
Yes, Your Honor.
So we're on the record in docket 22-02621. That is Mark Shmuel 2015 LLC versus Brooke Frank. Mr. Brown, did you have the opportunity to speak with Ms. Frank in a breakout room?
I did, Your Honor. Your Honor, Ms. Frank has mailed in some money orders that are not reflected on the tenant ledger, and she is also at a satellite office dropping off more money right now. And I believe we'd like to just get another adjournment if the court will allow us so that we can find all these payments since they were mailed during obviously Christmas week and
Right.
get them applied to her ledger so that we'll have a better understanding of exactly what amount of money is due, if any. Thank you.
All right. I can give you a control date, and then if you contact the court, because we're pretty backed up, I can give you a control date, and then you can let us know if we actually need the date or not to set it for formal hearing. The earliest date I have right now for landlord tenant is February 27th.
Okay.
So I'm gonna set it. So I'm gonna indicate that the parties met and the tenant mailed in rent. I'm scheduling it for February 27th.
Okay.
At 2:45. But Mr. Brown, if I will tell you this, if you find out that there is a discrepancy with the money orders or something along those lines, and you want it heard on a sooner date than that, let my staff know and we'll look to see if we can get it in sooner, in case there's a discrepancy, okay?
Understood, Your Honor. And if we receive the money orders or get information that they have been, cashed and her balance is zero here in the next couple of days before we hit January, then I'll be filing a dismissal.
Perfect. That do you understand that, Miss Frank? If all the money
yes.
comes in before the new year, then Mr. Brown will contact my office and we'll be submitting a dismissal. All right, ma'am?
Yes. Is there any way he can contact me if because the money orders that I sent, they said they've already been cashed. So if they don't have them, I can call Western Union to get a trace on it or something. Is there any way you can contact me if they don't have them or whatever?
May I talk directly to Ms. Frank, Your Honor?
You may.
Ms. Frank, do you have any court notice paperwork on you right now? You're going to see my telephone number typed on almost every court notice.
Oh, I don't have one. Okay, though. I think I threw it away. I thought I was done.
Right now?
Yes.
Okay, ready?
All right.
Yes.
517 372
Okay.
8500.
Okay, thank you so much.
Great, thank you. Thank you, Your Honor.
All right. So this is set for February 27th at 2:45 as a control date, but both parties know that they can reach the court earlier in regards to setting either an earlier hearing or a dismissal of the case. Anything else, Mr. Brown, on docket 22022621?
Nothing at all. Thank you.
All right. Anything else, Ms. Frank?
No, sir.
All right. You're all set. Thank you for your
Thank you.
appearance today.
Yes, thank
And
you.
then, Mr. Brown, we also have docket 22. I'm losing track of these. Is it 22022628? I have 628. We just did 62. Let's see.
I think the only case I have left is 2622.
Let me see. Do you have 20? I might have, because this was the witty file. You might have 22. This is 28. I bet you I switched the witty file with the second Brown file. Hold on, Mr. Brown. Let's see. We're tracking down that file.
Thank you. It is ZATD is my client's name, Orgarno, versus a Miller, a Cheyenne Miller.
I found it, Mr. Brown. I found the file.
Dang, I'm sorry. Good.
So we're on the record in docket 22-02622. That is Yoshai Zat versus Cheyenne Miller. Mr. Brown, your appearance for the record.
Yes, good afternoon, Your Honor. Attorney Chris Brown representing plaintiff.
And the defendant in this case is Cheyenne Miller. I do not see Miss Miller. You're here. Come on forward. Okay, you can have a seat. Miss Miller, you are Cheyenne Miller?
Yes, Your Honor.
You're not represented by counsel today.
No, Your Honor.
All right. This is the time set for a formal hearing in the matter. Are you ready to proceed to formal hearing?
Yes, Your Honor.
Would you prefer to maybe see if you maybe talk to a legal representative of the landlord to see if there's some issues you can resolve rather than go to formal hearing?
Yes, Your Honor.
Mr. Brown, would you be amenable to talking to Miss Miller in a breakout room to see if you can come to an agreement on some of these matters?
Yes, Your Honor.
All right. So Miss Miller, I'm going to have you put on an iPad with my court officer, and then we're going to put you both, Mr. Brown and yourself, in a room so you can discuss some of these matters. Okay?
Yes, Your Honor.
All right.
Thank you, Your Honor.
Thank you, Mr. Brown. All right. So, Mr. Kesky, you're here on Ms. Sheeran. Is that correct? Oh, you're here on Mr. Kessler.
Yes, Your Honor.
All right. And are you James Lem?
Yes, sir.
All right. And then, so let's do, and let's see, who else do we have? Do we have Clinton Davis here? Is anybody here from Woodbridge Apartments?
Your Honor, I am the attorney of record on the
All right.
Clinton Davis case for the plaintiff, Woodbridge Apartments.
All right, let's go ahead and call that case. So we're on the record in docket 22-01567. That is Woodbridge Apartments versus Clinton Davis. Will the parties please introduce themselves for the record?
Good afternoon, Judge Christopher Asphalt on behalf of the plaintiff, 53129.
And Mr. Davis is not in the Zoom courtroom. I don't believe he's in the physical courtroom. This was scheduled for 2:30. It is now 2:46. I have. So it appears that the defendant has failed to appear at this time. Mr. Asfaq, how would you like to proceed? I will note for the record that the defendant failed to appear on an October 5th pretrial. And then I have on that time that the defendant failed to appear, and then case was dismissed without prejudice, and then we're here on a second formal hearing. So maybe Mr. Davis showed up late that day and then had a second formal hearing set. I'm uncertain, Mr. Asfaq.
Exactly, Judge. Let me try and clarify. I believe what happened is that it was my office that failed to appear at the second hearing.
Okay.
And the reason is at the first hearing, my note said I was to show up at 2:15, but the court called it at 10:15. So either I misunderstood it or the court set it for a different hearing. But in any event, the case was dismissed because I showed up at the wrong time. So that's why I'm requesting that the matter be reinstated. There, no party will suffer a prejudice if the court chooses to do so.
Perfect. And it does appear that on a previous August 17th date, the defendant failed to appear at some point. So
that is correct.
There's no doubt the defendant's failed to appear today. So how would you like to proceed today, Mr. Asfaq?
Well, I mean, I don't know if it would be appropriate to seek a default judgment at this time, but I guess I would just request that the court enter an order setting aside the dismissal and perhaps setting this for a hearing and then sending the notice of the new hearing to the defendant.
All right. So I'll set aside any dismissal that was indicated for the record. And we will reset for formal hearing. Just kind of a belt and suspenders approach, really, to make sure that Mr. Davis has notice. I have my earliest date right now is in February. So that would be February 27th at 2:45.
I mean, obviously, I'd like a sooner date, but I understand if that's the court's next available date.
Yeah, that's the next. We went through most of February today.
Right.
And the court, and then Mr. Davis will receive notice for that date from the court.
Okay, and so the court does not need me to submit an order setting aside the dismissal or anything like that?
I've said it for the record. It wouldn't hurt if you if you set in an order to set aside the dismissal. I've indicated for the record, but I think to make our civil partners happy, to have an order to set aside the dismissal would be prudent.
Okay, I will do so, Judge.
All right. Anything else for the record, Mr. Asbach?
No.
All right. Thank you for your appearance. That's all for 22-01567.
Thank you.
We're back on the record in docket 22-02622. And Mr. Brown, that's your case?
Yes, Your Honor.
You've had the opportunity to speak with Ms. Miller concerning this case?
I have, Your Honor, and we are requesting an adjournment on this one as well for basically for two different reasons. She mailed out some money orders on Monday, as in 2 days ago, that are not reflected on the ledger because we haven't received them yet. And also, this case, Your Honor, involves a car that the tenant crashed into the garage with about $6,000 worth of damages. So we're trying to come up with a payment plan on that damage to the garage repair as well. So there's two different issues. Obviously, the tenant crash into the garage obviously is not rent, but it is damage.
All right. So tenant has released funds that the landlord has not received yet.
Correct.
And then there's an outstanding issue with damage to the garage.
Correct. And also December rent, I believe. I believe she indicated that she only mailed out payments for October and November.
All right. As you know, Mr. Brown, if we adjourn it, my closest hearing is in February.
Understood.
So that would be, how am I on my 2:45 dates? Or are we at 3 o'clock? Right now? Okay. Okay. So 2/27.
Yes, Your Honor.
February 27th at 2:45. Of course, if you find out earlier that you don't need that date, you know where to find us.
Understood.
Ms. Miller, do you have any questions of me? This is adjourned to 2/27 at 2:40, February 27th at 2:45. In regards to the allegations in this file for formal hearing. And it sounds to me like there's some money that's been sent and we're just waiting to see what the total of that would be. Okay, ma'am? All right. Do you have any questions? Any other questions of me?
No, Your Honor.
All right. Anything else for the record in 22-02622, Mr. Brown?
Nothing at all, other than the fact that Ms. Miller has indicated she's going to send emails and with a proposed payment plan on the damages. I would advise her strongly to do that, please.
All right. Did you heard that, Ms.
Yes,
Miller?
Your Honor.
All right. All right. So that's all for the record in 22-02622. Thank you, Mr. Brown. Thank you, Ms. Miller.
Thank you, Your Honor.
Thank you, Your Honor. And Your Honor, I believe
Thank
that
you, Mr. Brown.
concludes my matters today.
All right. Thank you,
Thank you.
Mr. Brown. We'll see you next time.
Thank you, Your Honor. Happy New Year.
You too. All right. Now we have, did we do Woodbridge Apartments already? What files I have left? So we have Fusion Notes and Matrice Thomas and LaDante Thomas. Like I set aside the judgment and it was set for new hearing that nobody showed up for. I don't know what that means. Yeah. All right, we're on the record in docket 22-02624, Fusion Notes LLC and versus Matrice Thomas and LaDante Thomas. Will the parties please introduce themselves for the record? Is there anybody here representing Fusion Notes? Is there anybody here representing Matrice Thomas or LaDante Thomas? I have notice set out and mailed as of 3 weeks ago to both Matrice Thomas and the attorney for the plaintiff, Ethan Hill. Sir, are you Matrice Thomas or LaDante Thomas?
LaDante Thomas, yes.
You're LaDante Thomas?
Yes.
You're just in under the wire.
I was sitting in there, but I just heard you in a microphone say my
All
name,
right.
so I came in.
All right, Mr. Thomas, go ahead and have a seat. I'm going to call your case 22-02624. Sir, you are LaDante Thomas?
Yes.
And is Matrice Thomas is not here today?
No.
All right. Is she working or?
She's not working currently. No, we
But-
actually separated right now.
All right.
So, yeah,
So you're uncertain of her whereabouts, but you're representing yourself. All right. And you did receive notice of this. Obviously, you're here.
Yes.
Have you been in contact with Mr. Ethan Hill, in regards to this matter?
I'm not really sure who that is, but I did speak.
Is that a lawyer?
I think so. I did speak to someone about this, and the main person I was talking to was a gentleman that was representing for Fusion Notes.
Okay.
His name was Saul. That's been the main gentleman I've been talking to.
All
Not
right.
to say that I hadn't talked to Ethan though. I just
All right.
Saul been the main guy.
And
Actually, Ethan, yes, he had me on 3 where I think they the ones that came out there to the house and took pictures
all right.
That's
When,
what happened.
what day was that, sir?
yesterday.
Yesterday?
They came out yesterday and took pictures.
All right. Well, I have you here in representing the defendant. I have nobody here, and hearing is in person for Fusion Notes, and they appear to be out of Ohio, Middleburg, Ohio. I'm not sure.
I mean, I just send my payments in.
All right.
And, you know,
But at this time, because the plaintiff failed to appear and did appear to get proper notice of this. This is a land contract case? All right. And instead of setting the dismissal aside, which if they didn't get proper notice, I'm gonna adjourn this matter, okay? We'll adjourn this matter. This is a land contract forfeiture, so it's a little different. And we're gonna reset it for another date, okay?
all right.
I'm gonna give, that might save some paperwork if you just talked to them yesterday and they were out taking pictures of the house.
Yeah.
So I'm gonna indicate plaintiff failed to appear. Defendant Thomas Matrice
It's
appeared.
LaDante though, but yeah.
LaDante, I'm sorry. LaDante Thomas appeared. And we are going to reschedule for February 27th, 2023 at 3 o'clock. And that'll give us a chance to figure out, this case has a little different because there was notice by publication at some point. There's some question of whether service was good. There was a judgment set aside already. So maybe we should, since you're communicating with the landlord now in regard to the land forfeiture, let's regroup and get all together so we can see what issues we have. All right, sir? All right, so there'll be February 27th, 2023 at 3 o'clock, right, sir? You're all set today. Thank you for your appearance.
Appreciate you.
And then we have Mr. Keski, your case, Cullen's property,
Yes, Your Honor.
and Daniel Kessler. And Mr. Kessler's not here?
He was in the hallway.
All right. Sir, are you Mr. Kessler? All right, you can go ahead and have a seat over here. And you can sit wherever you want here. On this side's fine. All right, we're on the record in docket 2202648. That is Cullen's Property LLC versus Daniel Kessler. Will the parties please introduce themselves for the record?
Good afternoon, Your Honor. Don Keski for the plaintiff, and also I have as a witness Mr. Kip Wilson of Renaissance Property Management, who was the owner's agent for the property.
All right, thank you. And sir, you are Daniel Kessler?
Yes, sir.
Okay. And Mr. Kessler, you are not represented by counsel today, is that correct?
No, sir.
All right. And you indicate you know today was set for formal hearing. All right. And you're going forward today without counsel today, is that correct?
Do I have counsel available? I've always been open to counsel. I don't.
Well,
if I can have counsel.
Well, at the pretrial, it was set for formal hearing, and there was a video shown of all the various ways legal services of South Central Michigan, various aspects to get counsel. That was in October. Now we're at the end of December, and you've shown up today without counsel. So I'm assuming you're representing yourself today.
I can. I mean, I'd be willing to.
Okay.
I was under the impression, though, today that legal services of South Central Michigan couldn't help.
All right. So did you make application there?
Yes.
And you were denied?
Yes.
Okay. So yeah. So now it's incumbent upon you to seek counsel on your own or to represent yourself.
Okay.
Okay. Mr. Kessler, are you ready to proceed with proofs today?
Yes, I am, Your Honor.
All right. You may proceed.
Your Honor, we are going to be presenting testimony and exhibits in support of the notice to quit that was sent out on June 8th, 2022, but also for possession judgment and for money judgment for substantial amount of rent that's compiled since then. And I'd call as the first witness, Mr. Kip Wilson of RPM.
All right, Mr. Wilson, you can come up here. You stand right in front of me and state your full name for the record.
Kipling Cornell Wilson.
Okay, and how do you spell your last name, sir?
Wilson.
Okay, and have you raised your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right, go ahead and have a seat here, and please project as loud as you can for the recording device.
Yes.
You may proceed, Mr. Kessler.
Mr. Wilson, could you describe your management role with respect to this tenancy in this property?
Yes, Renaissance Property Management is a fee management company, and we were hired to manage this small 6-unit building.
And are you familiar with the books and records applicable to this lease?
I am.
And let me first hand out plaintiff's exhibit 1, Your Honor, which I would request be identified by the witness.
All right. Thank you, Mr. Keski.
I've also provided a copy of this exhibit to the defendant, Mr. Kessler.
All right. The record will note that you provided a copy.
Mr. Wilson, could you please explain what this plaintiff's exhibit 1 is?
Just in 1 second when we'll mark it. And then we'll proceed. So we'll mark the copy you gave us and use that as an exhibit. All right, you can proceed, Mr. Keski.
Mr. Wilson, can you identify this exhibit, plaintiff's exhibit 1, and describe what that shows?
This is a tenancy worksheet that we prepare prior to going to court, showing rental arrears, court costs, possessory judgment amount, and money judgment amount for a particular court date for a particular tenant.
And as of the preparation of this exhibit, could you explain for the record the amounts of rent and court costs in total that you're seeking for possession judgment?
Yes, the possession judgment is $4,866.25. Court costs is $212.76 for a total possession judgment of $5,079.01. The money judgment is $4,101.25 in rent arrears. Partial rent through today would be $644. Cart cost of $212.76 for a total of $4,958.01.
And Your Honor, I'd like to next hand out plaintiff's proposed exhibit 2.
All right. I'll have my court reporter mark that.
I'm also providing a copy to Mr. Kessler.
Okay, so we'll mark that. We'll have the second exhibit marked. And you may proceed.
Mr. Wilson, could you identify this exhibit and also explain what this shows?
Yes, this is a tenant transaction notice. We keep these computer generated for every tenant that we manage for. And this just shows from June of this year. Current balance of rent that was charged, payments that were made by Mr. Kessler, filing fees, attorney, the court costs, so forth for filing this matter. And the last is the $5,079.01, which is the current balance as of today.
And that's the same balance as you show on plaintiff's exhibit 1, is that right?
Correct.
Now this plaintiff's exhibit 2 is a kind of a document that is recorded on a regular basis as part of your business records and managing properties, including this property?
Yes, for all tenants.
I'd next like to identify plaintiff's exhibit 3, Your Honor.
All right. Thank you, Mr. Keski.
also providing a copy of this exhibit to Mr. Kessler. Could you please identify,
Right, 1 second, and we'll let the court reporter make sure that it's been marked. All right, Mr. Keski, you may proceed.
could you please identify, Mr. Wilson, what plaintiff's exhibit 3 is?
This is Mr. Kessler's original lease with Renaissance Property Management for the property at 915 Eureka, unit number 10. And it started 6th of April of 2017 and ended April 11th of 2018. And then the last page of exhibit shows a renewal that was sent to Mr. Kessler that he extending his lease, new rental rate, signed and sent back in April of 2020.
And this last page of the lease, as extended, would extend the lease according to the third bullet in the middle of the page up through April 15th, 2021. Is that correct?
That is correct.
And has Mr. Kessler been on a month-to-month basis in terms of the lease of the property since then?
Yes, his tenancy's been month to month since that date.
What date is that again?
Your Honor, that date is April 15th, 2021.
Okay.
Right, next, proposed plaintiff's exhibit 4.
Sure.
Thank you.
Right, plaintiff's exhibit 4 marked.
Mr. Wilson, could you
And
please?
just 1 second, and we'll make sure it's all typed in. Thank you. You may proceed, Mr. Keski.
Mr. Wilson, could you please identify plaintiff's exhibit 4 and explain what this is?
This was a notice that we sent Mr. Kessler in April of 2022. Letting him know of a rental increase and that his lease was still staying on a 30-day month-to-month tenancy, so there was no extension of the lease, but there was an increase in the rental rate at that Mr. Kessler started to pay.
And as this indicates on plaintiff's exhibit 4, the rental rate of $605 per month starting June 1st, 2022 is on the condition that payment is made on or before the first of the month. Is that
Yes,
correct?
that is correct.
And if that payment's not made by the first of the month, then you do have late fees, which would then accumulate. Is that
Yes, that
correct?
is correct.
And that would be shown on your transaction history, would it not, on plaintiff's exhibit 2?
Correct.
I would like to next propose plaintiff's exhibit 5.
Thank you.
And I'm providing a copy to Mr. Kessler.
All right, and as soon as we get it marked, then make sure that it's admitted in the computer. Thank you. You may proceed, Mr. Keski.
Mr. Wilson, can you identify plaintiff's exhibit 5 and explain what this is?
Yes, this is a state of Michigan notice to quit to recover possession of property that we sent to Mr. Kessler and all others that might be occupying the unit on June 8th, 2022. And that his lease had expired, or he was on an expired lease, and that we had given him more than the 30-day notice because we just made it till July 31st of 2022.
And the notice to quit date that's shown on the exhibit was what date?
It was mailed on June 6th.
And the signature that appears on this notice to quit, is that an employee of your
Yes,
company?
it is one of my employees.
And she acts under your supervision?
She does.
Your Honor, I'd like to propose our next exhibit, plaintiff's exhibit 6.
Thank you.
I'm providing a copy to Mr. Kessler.
All right, we'll have this marked as plaintiff's exhibit 6 and enter it in the computer. You may proceed, Mr. Keski.
Mr. Wilson, can you explain what plaintiff's exhibit 6 represents?
This is through our property management software, along with the payment ledger. This is also a history of notes of any incoming and outgoing communications with our residents. And so showing notices of contacting of the tenants, maintenance requests, filing fees, court fees. It's just a very detailed record of a tenant's history with us.
And this is a business record that you utilize your software to record for with respect to all properties and leases?
All properties and leases, yes.
And are the persons who make entries on this log and receive contacts to and from tenants, are they acting under your supervision?
They are.
And they're members of your staff, are they?
They are, but some of the items on here are just computer generated. For example, if a tenant calls us, it's automatically recorded, so there's no human involvement. It's if the software recognizes the phone number of the tenant or their email address, it's automatically updated to their history and notes.
And responses to messages are then also recorded in the log?
Correct. If they're used, the phone system. Now, not all phones, obviously. If I use my cell phone or something, it would not be part of the system. But if they called from the office, those phone numbers, those calls are recorded, both our conversation and the tenant's conversation.
Now, with respect to this property, has the city of Lansing attempted to undertake an inspection of the unit?
Yes, City of Lansing has a regular inspection schedule, and we've not been able to gain access to Mr. Kessler's unit for two rental cycles.
And what's the reason for that?
The last in May of this year, Mr. Kessler did allow the inspector to enter his unit, but he would not let me enter, and he refuses to let any employees do any work in his unit or any corrections.
And that's to meet any upgrades or changes the inspector might want.
Correct.
Now, has the city placed a red tag on this apartment unit?
No, the unit is not red tagged, it is pink tagged, his unit.
What does that mean?
There was 30 days for either resolve the maintenance issues or the tenant is no longer allowed to occupy the unit.
And what's the date under which he cannot occupy the unit, if you know?
With the conversation with Mr. Kessler and I earlier today, I believe it's the 5th of January.
Now, Your Honor, I would propose that exhibits 1 through 6 be admitted into evidence.
Okay, you've had the opportunity to see exhibits 1 through 6. Do you have any objection? Without objection, plaintiff's exhibits 1 through 6 are admitted into evidence.
Your Honor, at this time, we would complete Mr. Wilson's testimony, subject to the right to call him as a rebuttal witness. And this would be in support of the requested possession judgment for rent, unpaid rent, and for money judgment, and also to enforce the notice of notice to quit, so that the Mr. Kessler would be required to move out of the apartment because his lease expired a long time ago. He's been on month-to-month lease, and he received a notice to quit that gave him more than 30 days notice, and that's not been complied with, and the tenant has not paid any rent since then.
Thank you, Mr. Keskey. Mr. Kessler, do you have any questions of Mr. Wilson?
Yeah. Was it that called me? And I mean, my rent was paid.
No, just ask a question. Who was it? Was it called you on what date?
Who was it that called me? The girl that works for you called me and told me I had to go on July 1st.
Look at the history and notes, John.
Because
You may.
that's,
They're all admitted, so you can look at them
I mean,
in order
that
to.
on there, there was a phone call to me by someone from your staff, a female, and
So
I'm
then-
curious where that is, because that is what started round 3, is when she called me. And there was a phone conversation that got kind of ugly, is what started this whole tiff.
And it's July 1st of what year?
It's, I don't know the exact date, Your Honor, because
Your Honor, I can read it.
Okay, so who was that person is the question.
Pam was an employee of mine.
All right. So that's the answer to the question.
Is it here?
Yeah, it's July 29th at 1:04 p.m. Would you like me to read the notes? It's on the first page.
Okay.
It's at 1:04:58 p.m.
Yep.
That's the first page of plaintiff's exhibit 6.
Yeah, so that was the thing. Well, what I don't understand is why did I have to go? I mean, I was paid.
That's the purpose of this hearing. So, I mean, that's the purpose.
How did I get the judgment on June 8th, if I was paid on June 1st? I think I mean, they were trying to throw me out. They were trying to throw me out because of the problems we had earlier. It was retaliation for that.
So you refused to pay after that?
Yeah. Basically.
All right, thank you. Any other questions?
No.
All right. May this witness be excused?
Yes.
Mr. Wilson, you're excused. Mr. Keskey, any further proofs today?
No, Your Honor.
Mr. Kessler, do you have any proofs for the court to consider?
No.
So the plaintiff rests, the defense rests in this matter. Mr. Keskey, any summation before the court makes its decision?
Just extremely briefly, and I know people promise that to you many times, that doesn't happen, but basically, he was properly issued a notice to quit. He was on a month-to-month basis. The landlord and his agent has the right under law to decide not to continue to rent under the month-to-month basis. The notice to quit was sent several weeks in advance of the move-out date, and the tenant has not paid part of June 2022 rent and has not paid any rent since. And so the landlord, the owner, is suffering irreparable harm, Your Honor, at this point. There's got to be some correction of this situation, and we would ask them for the judgment for possession and a money judgment, and that the notice to quit be enforced, Your Honor.
Thank you. Mr. Kessler, anything you want the court to consider before the court rules in this matter?
No, sir.
All right. Well, by the standard here is a preponderance of the evidence. We have 6 exhibits, one testimony from Mr. Wilson indicating I would defer to the summation. The 6 exhibits indicate that there is rent due in the amount of $5,079.01. I think there's an indication from the record itself that the rent has not been paid through December, November, October, September, August, July, and June. A partial payment in June of $276.65. Therefore, for non-payment of rent, I find that by the preponderance of the evidence that the plaintiff has proven their case. Based on the 6 exhibits and the testimony of the property manager, Mr. Keski, do you have an order for me to sign in that regard?
Not yet, Your Honor.
Okay. Well, so that's the order of the court, is that the defendant or tenant is to provide possession pursuant to the writ date, which will be 11 days after my date of signing. So if you provide it to me, it'll be 11 days after that date of signing that the judgment will go into effect. So if I sign it tomorrow, it'll be January. And it's not, and there's no court date, so it's January 7th, I think. It's January 7th. Yeah, January 7th. And then there are possession, past rent damages of $5,079.01, and costs of that's the total. The rent is $4,866.25. The cost is $212.76, with a total of $5,079.01, which will be part of the order to be submitted.
Judge.
What's that?
9th.
Through the 9th. So if I sign it tomorrow, it'll be January 9th.
Yeah, the 7th is a Saturday.
All right. So if I sign it tomorrow, the writ date will be January 9th. Regardless, it'll be 11 days after I sign it.
And Your Honor, we can email that to the court clerk, or do you have a separate?
You can probably send that right.
Send it to the court clerk.
Okay, send it to the court clerk and they'll provide it for me to sign.
Yes, we'll email that in tomorrow.
Okay. Anything else for the record in docket 22-02648, Mr. Keski?
No, Your Honor.
Mr. Kessler?
No.
All right. So it'll be around January 9th is your move out date for certain. So just keep that date in mind. Nothing else for the record in this file. Everybody have a nice day. Thank you for your appearance.
Thank you, Your Honor.
Thank
Have
you,
a
Your
nice
Honor.
New Year.
And then Ms. Sheeran, you're here for the 22-2649. You'll have to unmute yourself, ma'am. And then Mr. Lem, you're up here also for that case.
Thank you.
Yours. Merry Christmas.
Merry Christmas. Happy holidays.
Sorry, I'm sorry, Judge. I was having some troubles with my phone.
All right, Ms. Sheeran. So we're on the record in docket 22-02649. That is Crystal Sheeran versus James Lem. Will the parties please introduce themselves to the record?
I'm James Lem.
Okay. And ma'am, you are Crystal
Judge.
Sharon?
Yes.
All right. This is the time set for a formal hearing for non-payment in this matter. I'm going to briefly inquire, Mr. Lem. Mr. Lem, you had a pre-trial on October 26, 2022, in which a video was showed for the various aspects of getting a lawyer. You are not represented by counsel today, is that correct?
Yes, I was denied.
Okay. And so this is the time set for formal hearing. Have you had the opportunity to speak with Ms. Sharon concerning some of these matters? Or is it your intent to go forward with the hearing today?
Go forward with the hearing today.
All right. Ms. Sharon, is it your intent to go formal with the hearing, go forward with the hearing today?
Yes.
All right. All right. The standard is preponderance of the evidence. You just saw kind of how we do it here. Ms. Sharon, you have the burden of proof. Crystal Sharon, as the landlord or representative of the landlord today. Did you want to testify today?
Did I want to testify?
Yeah, this is the it's time for formal hearing. So you need to provide me with all the evidence that you'd have in making the allegation against Mr. Lem concerning his non-payment.
I sent you a letter, Judge. Did you get it?
I did. So
So you pretty much just want me to tell you why I want to cancel the land contract?
Yeah, for the formal, so you want to cancel the land contract. The letter is not a part of the evidence. So did you want the letter marked and admitted as part of the evidence for the formal hearing?
Yes.
All right. So I did get the letter. Have you seen that letter, Mr. Lem?
No, sir.
All right. I'm going to take this opportunity to have the letter from Crystal Sharon marked by Wendy, and then we'll show it to. Yeah, why don't we make a copy? Let's make a copy of the letter, because what's in the court file is not necessarily part of the evidence of the hearing, Ms. Sharon. So we're just going to make sure that this formal hearing has all the evidence associated with it.
Okay.
So let's make a copy of it, and we'll be back with you. Right, and we'll have that marked as Plaintiff's Exhibit 1.
Your Honor, can I speak?
You sure can.
Do you have the original documents from the
I
first
do
hearing?
have the complaint, the initial complaint you filed. The letter was not a part. Since you're going to be speaking about the letter, I figured it was best to make it an exhibit.
Okay.
All right. So Ms. Sheeran, let me swear you in before you testify. I'm gonna have you raise your right hand. Spell your last name for me, ma'am.
Sheerin.
All right, Ms. Sheeran, do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right, and you are Crystal Sheeran, and you live in Winston-Salem, North Carolina.
Yes, sir.
All right, ma'am. Tell me the nature of the allegations for the land contract, the forfeiture of the land contract, ma'am.
Yes, he forfeited the land contract because he has not paid the taxes, which was stated in the land contract, and also he's been behind multiple times for rent to own, and
so what years did he fail to pay taxes for?
2019, 2020, 2021, 2022, and I have the amounts here right now. I just got done paying to save my house just recently, a couple days ago.
And since then, which is a part of the land contract to pay the taxes, you indicated that he was to pay a certain amount of land contract rent per month in order to stay in the residence or the house?
Yes.
And how did he do it? When was the date of the land contract agreement?
It was July 12th.
Go ahead. July 29th?
Sorry, hold on. I just want to look at my old papers.
All right.
It was April 12th of 2020.
Yeah, April 12th of 2020. And how much was rent supposed to be a month?
It was supposed to be $650.
All right. And was Mr. Lem able to pay $650 a month since April of 2020?
He does pay the $650, but it's always past the due date.
Past due date. And what is the due date pursuant to the land contract agreement?
So the land contract was the due every 12th.
Okay. And you would receive payment, you would just receive payment late.
Yes, sometimes it would be on times, but most of the times it would be late.
All right. And but payment is up to date on this matter up until December of 2022.
For the land contract, payment is not up to date. He did not pay July and August for the land contract agreement.
What? Did not pay July and August concerning the rent?
He did not pay of July and August of 2022 for the land contract agreement, but me and Mr. Lem made a verbal agreement of a new contract, which was rent month to month. But since he wanted to proceed with the hearing, I no longer want him, I no longer want to rent to him anymore.
All right, so the month to month, what was the new month to month payment supposed to be?
$700.
So your testimony today is that he's been in violation of the land contract agreement in regards to late payments and failure to pay taxes, which is a part of the lease, part of the
yes.
Original agreement for the years 2019, 2020, 2021, and 2022. Do you have a total amount in that regard?
I do, sir. It is $4,419.72.
$4,419. And how much?
And 72 cents.
Okay. And was the land contract supposed to, was supposed to go up until the time of the purchase price of the agreement to sell, which is $43,000?
Yes.
All right. Anything else you want to tell the court, Ms. Sheeran?
No, not that I can. No, not that I can think of, unless you want to talk about the letter that I wrote you.
No, I made it a part of the exhibit, and I'll read it for the record. Okay. I'm writing to you a summary of what has been taking place between me and Mr. Lem. I started a land contract property of 826 Clayton in 2019. Mr. Lem has been struggling to make the payments. Since the very first payment, he's never paid me on time. This went on for about 1.5 years. I was understanding as much as I could. Then I got notice last year the taxes were behind and that the house was going into foreclosure. I talked to Mr. Lem numerous times about paying the taxes. When he finally made a payment, it was a day before foreclosure day. After that, I talked to him and asked when he will get the taxes paid. He said he does not have the money and he didn't know when he would have the money. I explained to him that the contract states the taxes are to be brought current or you will forfeit the house. After going back and forth, he accepted that he would not be able to pay them and he would just rent the house out. When then made a completely different agreeing statement, he would pay $700 deposit and $700 of rent. I filed paperwork and noticed the court date was months away. He tried to cancel the new agreement we had, tried to come up with money soon after the court date. I spoke to him and asked him about the new agreement we had and why did he disagree in court. He said it was because they gave him another court date, so I'm going to try and come up with the money. So honestly, I believe is not being able to come up with the funds needed to bring the balance up to date is just wasting my time at this point. The house is now back in foreclosure. He has not made any attempt to make a payment on taxes. I'm just ready to terminate this contract. I want him out of the house. I've received complaints from neighbors about drug trafficking, loud music, cars parking in the wrong place and blocking their driveway. Wow. I'm just tired of the confusion and the broken contract. I'm moving forward. I'm asking court to terminate the contract. Sincerely, Crystal Sharon. That's the nature of the letter that was written to the court.
Yes.
All right. And Mr. Lem, you have a copy of that?
Yes, sir.
All right. Mr. Lem, did you want to provide evidence to the court today?
I would like to. I have no evidence, but I'd like to speak.
All right. So I'm gonna have you raise your right hand. State your name and spell your last name for the record.
My name is James Richmond Lamb.
Okay.
L-E-M-M.
All right. I'm gonna have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right, Mr. Lem, you can make your statement to the court.
All right. I'm gonna address. I have told her when I was gonna pay it, when I could pay it. I told them I found my income taxes. I know I got plenty of money coming. I'd pay it all off then. And they said they was, for one, I never have talked with her. I always talk with her boyfriend. I never had a conversation with her about this house, nothing. So this is all a lie. She never called me. She never said nothing. I talked to her man. The reason why I agreed, the reason why I gave him the $700 for the month on September is because I got approached at my house. 3 fellas came over and told me I'm gonna come up with some money right now, or they're gonna throw everything out the house. And he said, well, just give me $1,000 right now and we be good. $1,000 for rent, $700 for the $700, and then $300 for deposit, whatever. My kids was right there. They was all loud and stuff. I wasn't trying to fight nobody on my front porch about no rent because I have 2 houses, and I always pay my rent. I don't always pay my rent on time, but when I don't pay it on time, I always give them the late fee. The late fee is only $25. I have gave them $75 for late fee every time. I'm not understanding, and it's never more than a week late. So the bill was the agreement was $25. I give them $75. I put $8 grand into this house. I only owe about $19,000 or whatever onto it. I have everything paid off by the first week of January, February, March when I get my taxes. Every dollar, and I don't owe them $1. I gave them extra money. I gave them $1,000. I gave them $1,000 on September, and then I gave them, and then the next October I gave them $800, the extra $100. So I gave them, and then plus I gave them extra $50 each month, and they changed it to the first. And then twice I had people come knock on my door and threaten me. Not once have I had a conversation with this lady. Not once have I told her I didn't know when I was coming up with the money. Not once have I had no drug trafficking at her house or nothing like that. That's what I'm not. People have parked in the wrong driveway, and I went over and I apologized to the lady. But no drug trafficking. Ain't nobody even there but to do drug traffic. Never had the police call to that house, nothing. So I don't even know where, I guess the drug trafficking sounds good to them.
Do you have any exhibits you'd like to admit to the court today?
No, Your Honor. No, I do not.
Do you have any witnesses to testify on your behalf?
No, I do not, Your Honor.
You understood today was the date for a formal hearing?
Yes, I
in which
do.
we were providing
Yes,
evidence. Did you pay property taxes in 2019?
I wasn't even there in 2019.
Did you pay property taxes in 2020?
Yes, I did.
Did you pay property taxes in 2021?
No, I didn't, Your Honor.
Did you pay property taxes in 2022?
No, Your Honor. No, I didn't, Your Honor.
All right. Ms. Sharon, any rebuttal on your behalf?
No, he did pay a one payment in 2020 2020, but that wasn't even enough to take it out of foreclosure.
So I'm going to rule, the standard here is a preponderance of the evidence. And I find that the plaintiff has met their burden by preponderance of the evidence, that the defendant has been in violation of the land contract agreement indicated by late payment and the failure to pay property taxes on at least 2 occasions. I won't count 2019, but I will count the 2020 and 2022. And therefore, the land contract has been violated pursuant to the agreement that was made. And so, Ms. Sharon, the only thing I can do now is you're going to have to provide. So you've met your burden of preponderance of the evidence. The land contract is now forfeited, so there's no land contract that's given up by the defendant's conduct. You're going to have to provide me with an order to sign to make that effect happen. Okay, okay. I can't. It doesn't happen because I rule on it. It happens when I sign the order, and then there will be a date. So without the land contract set, there will be a date of evictions as a part of that. And that'll be 11 days from when I sign the order, I believe. 10 days. I think a land contract, it's 10 days from the date I sign the order that the address, and so just so we're clear on the address we're talking about, and I'm doing that pursuant to the signed agreement from the seller, Crystal Sharon, and the buyer signed agreement on April 12th. That's James Lem. Both signed, and the property is 826 Clayton Avenue, Lansing, Michigan. Is that correct, ma'am?
Yes.
All right. If you follow that up with an order, I'm saying that because Mr. Lem, you're the one who's under the gun. You'll have 10 days after that order to find, at least to make that property turn possession over to Ms. Sheeran, okay? All right. Anything else for the record in docket 22-02649? Ms. Sheeran?
No, I have nothing else.
Okay, do you need the email address or do you need a contact number in order to make sure that you have the right order to sign that you submit to me?
Is it the same phone number to the courthouse?
It is. I can give you the civil department's number of 517-483-4426.
Okay, so it is 517-483-4426.
That's correct.
Okay.
All right. Anything further on the file, docket 22-02649? Ms. Sheeran?
That is all. Thank you, Your Honor.
All right, Mr. Lem, anything else?
So I'm sure she's gonna have it in. So I most likely have to be out by the second week of the next month, right?
Yeah, I'd say the 10th is is just any time around the 10th is going to be 10 days later. So you're playing with that number. You're playing with that date. All right. All right. That's all for the record. 22-02649. Thank you for your appearance, both of you.
Thank you.
Thank you.
I think we went through all the February days.
Drug trafficking. That's crazy. So crazy.